Most significant case regarding the Second Amendment in more than a decade.
It's a case that legal experts will be watching closely.
This case could reshape how far states can restrict your right to carry and wear.
Something fundamental just shifted in America, and most people didn't even notice it happening. While everyone was distracted by headlines and political theater, a series of court decisions quietly dismantled decades of restrictions that gun control advocates thought were untouchable. We're not talking about minor adjustments or technical tweaks. We're talking about foundational barriers that just collapsed one after another in rapid succession. And the people who built those barriers are now scrambling to figure out what just happened. This isn't about predictions or possibilities. This already happened. The dominoes are falling right now, and the implications are staggering. So let's walk through exactly what went down, why it matters more than you might realize, and what it means for the future of Second Amendment rights across the entire country. For years, the game was rigged in a very specific way. Authorities didn't need to ban firearms outright. That would be too obvious, too vulnerable to constitutional challenge. Instead, they played a much smarter game. They made exercising your rights so complicated, so time-consuming, so legally treacherous that most people just wouldn't bother. You could follow every rule perfectly, spotless record, professional training, pass every background check, and still end up treated like you were requesting something dangerous and suspicious. Entire cities became legal minefields where one wrong step could transform a law-abiding citizen into a criminal. Months of waiting, endless paperwork, bureaucratic hoops stacked on top of more hoops. And through it all, you could feel the unspoken message. They were hoping you'd just give up. That was the strategy. Exhaust people, confuse them, make them doubt whether it was even worth the trouble. Assume guilt first, maybe grant trust later if you jump through enough flaming hoops. But something changed. A major ruling punched a hole straight through that mindset. It didn't eliminate every obstacle overnight, but it established something crucial. There are limits to how much squeezing is constitutionally acceptable. And for the first time in a very long time, the pressure started shifting in the opposite direction. The people who spent decades tightening restrictions suddenly found themselves on the defensive. And what followed was a cascade of defeats they never saw coming. Let's start where the cracks became impossible to ignore. Tennessee became ground zero for a confrontation that had been brewing for years. State lawmakers had mastered a particular technique. Don't ban carrying firearms outright because that's legally vulnerable. Instead, carve up the map so aggressively that stepping outside your front door feels like navigating a legal obstacle course. Parks became off limits. Hiking trails became restricted zones. Public spaces where families gather with their children, same story. Everything closed off. This wasn't about safety. This was about pressure. Make the rules so convoluted and confusing that even responsible, law-abiding people choose to stay silent and stay home rather than risk accidentally violating some obscure regulation. It was restriction through complexity, control through confusion, and it worked for a long time. Then a judge finally said enough. They went back to the historical foundation this country was built on. Armed citizens moving freely through public spaces, not tiptoeing through warning signs and wondering if they're about to commit a felony. The state couldn't produce a single legitimate piece of historical evidence showing that citizens lost their constitutional rights the moment they stepped into a park or walked along a public trail. The argument collapsed, the ban fell, and here's why that mattered more than anyone initially realized. The second a court demanded actual proof instead of political assumptions, the spell broke. The message landed loud and clear. You can't shrink constitutional freedoms just by drawing more red circles on a map and declaring them restricted zones. One state stood up, and every other state watching closely suddenly felt the ground shake beneath them. But if you thought that was an isolated incident, watch what happened next. The spotlight shifted north to Minnesota, and this case hit differently because it targeted an entire generation that had been told to wait their turn. If you were 18, 19, or 20 years old, the message was absurd and insulting. You're old enough to vote in elections, old enough to serve in the military, old enough to pay taxes and be held fully accountable under the law, old enough to face real danger in dangerous neighborhoods, but somehow, according to the state, you weren't trustworthy enough to carry a firearm for self-defense while walking to your car after dark. That wasn't safety policy. That was condescension wrapped in legislation. So attorneys brought real history into the courtroom, not emotional arguments or political talking points, but actual documented history. They presented militia laws that required 18-year-olds to show up armed and ready to defend their communities. The founding generation didn't view young adults as helpless children in need of protection from themselves. They viewed them as accountable citizens with full rights and responsibilities. The court couldn't ignore that historical record, and the age barrier didn't just bend under scrutiny, it broke completely. No compromises, no half measures, no gradual phase-in, gone. Millions of young adults suddenly stood on equal constitutional ground to protect themselves. Another wall came down, another reminder that fundamental rights don't come with an arbitrary waiting age attached. That crack in the foundation spread faster than anyone expected. Then came something that genuinely shocked observers. Washington, D.C., the city internationally famous for turning tiny paperwork errors into life-ruining criminal charges, suddenly backed down. For years, using the wrong type of holster or making one minor mistake on a form could destroy your entire life. Meanwhile, the people actually causing violence and chaos in the streets weren't filling out any forms at all. But after the Bruin decision established new constitutional standards, the script flipped dramatically. Judges started pushing back against overreach. Defense attorneys began winning cases they would have lost automatically just months earlier. And prosecutors did something almost unthinkable in Washington, D.C. They quietly started dropping firearm carry cases they knew couldn't survive constitutional scrutiny. No press releases, no public announcements, just silent retreat. When the nation's capital, ground zero for gun control advocacy, starts backing away from enforcement, you know the pressure has fundamentally reversed. It's no longer aimed at gun owners. It's aimed squarely at the officials who tried to box them in. Courts don't shift this dramatically by accident. Something much bigger is moving beneath the surface. And then came the moment that almost nobody saw coming. California actually bent. Not through rumors or procedural delays, but through a direct court order with real enforcement power behind it. This is the state that built its entire political identity around tightening firearm restrictions, where virtually every new gun control measure in America seemed to originate, where permits and policies often felt specifically designed as obstacles rather than reasonable regulations, where bureaucratic delays and technical requirements sent one clear message: the government would decide when and how you could exercise your constitutional rights, not the Constitution itself. And presiding over it all sat the Ninth Circuit Court of Appeals, long viewed as the place where Second Amendment cases went to stall, weaken, or die quietly. Not this time. A long-standing firearms purchase limit fell, and it didn't happen through years of slow appeals or hidden legal maneuvering. The court's mandate issued firm and crystal clear, and it signaled something far bigger than just one statute collapsing. It demonstrated that even one of the most restriction-friendly courts in the entire country could no longer ignore the constitutional standard that's rapidly reshaping this legal landscape. Government offices that once relied on delay tactics and bureaucratic exhaustion now faced a very different reality. If California can't successfully defend a restriction in court, other states have even less ground to stand on. This wasn't symbolic or theoretical. It was a hard, concrete reminder that government control has a constitutional ceiling. For the first time in decades, California didn't look legally unbreakable. It looked exposed and vulnerable. And everyone watching closely understood exactly what that meant. Momentum is shifting direction. The grip once used to ration and restrict constitutional rights is beginning to loosen. Each ruling didn't just stand alone. It pushed the next one forward with greater force. So what does a ruling cascade like this really tell us? It reveals that the old strategy is fundamentally cracking apart. For years, the playbook was elegantly simple from the government's perspective. Don't ban rights outright because that's too legally vulnerable. Just choke them slowly. Make access feel like navigating a bureaucratic maze. Stretch public safety arguments into catch-all excuses that justify almost any restriction. Turn the process into a test of patience and frustration instead of a test of character and qualification. If enough honest, law-abiding people got exhausted and gave up, then the restriction worked perfectly without ever explicitly denying anyone's rights. That was the quiet logic driving policy for decades. But when courts start stepping in this boldly, it signals something deeper has shifted. Judges have finally reached the point where they will not pretend that restrictions are constitutionally harmless just because they chip away slowly rather than all at once. When a circuit court once notorious for siding with restrictions suddenly draws a firm constitutional line, everyone paying attention learns the same truth. The era of hiding government control behind paperwork and polite bureaucratic language is slipping away, and the officials who depended on confusion and delay felt it instantly. Of course, the moment power dynamics shift, the people who built the old system don't just accept defeat gracefully, they scramble desperately to preserve what they can. We saw this reaction almost immediately. Instead of learning from these rulings and adjusting their approach, certain lawmakers tried to repackage the exact same ideas under new labels, hoping nobody would notice the similarity. If they couldn't stop carry rights outright, they would simply shrink the geographic space where carrying applied. If rationing firearm purchases to once per month failed constitutional scrutiny, they floated compromise limits that changed the specific number but protected the underlying control mechanism. This wasn't about public safety anymore. This was about refusing to surrender authority they'd grown comfortable wielding. But here's the critical problem they now face. Courts aren't just skimming the surface of legislation anymore. Judges are examining motives and patterns, not just technical language. And every time a state tries to sneak in a cosmetically different but functionally identical restriction instead of genuinely respecting the constitutional ruling, it weakens their credibility when the next case inevitably hits a courtroom bench. The harder they cling to the old control mindset, the clearer it becomes that control, not safety, was always the primary objective. And that realization is beginning to cost them ground they once thought was permanently secured. All of this might sound like abstract courtroom battles and legal filings, but the impact isn't theoretical at all. It lands in actual lives. Think about a young woman who closes her retail shop after dark in a dangerous part of town. For years, she followed every rule, filled out every form perfectly, and still had to walk to her car alone with one thought dominating her mind. If someone attacks me, I'm completely on my own until police can arrive. That quiet, constant fear was treated as perfectly acceptable. Now she finally stands on equal ground with anyone who might mean her harm. She isn't waiting behind bureaucratic paperwork anymore. Picture a college student heading home late from the library. 18 years old, responsible, properly trained, but treated as if he had no judgment or maturity. Courts just reminded everyone that legal adulthood isn't optional, and neither is the fundamental right to stay alive. Or consider the father traveling with his family, terrified that crossing one invisible jurisdictional line on a map could transform him into a criminal over a minor technical detail. The new constitutional standard doesn't erase every problem, but it protects people like him from being punished for doing what any responsible parent would do, taking his family's protection seriously. These decisions aren't abstract legal theory. They change actual nights, real commutes, daily walks, and human lives. And when you line these victories up chronologically, the pattern becomes impossible to ignore. One state winning a case isn't noise. Two isn't luck. Then you get a third, a fourth, and suddenly even a major appellate circuit shifts direction. That's not random judicial variation. That's genuine legal momentum building. What used to be rare, celebrated victories are now stacking consistently. Case after case, judge after judge, until the pressure finally swung decisively in the opposite direction. Instead of watching rights get chipped down incrementally, we're watching old control points collapse, one ruling at a time. That only happens when the constitutional foundation under the old playbook starts fundamentally giving out. Rights grow stronger when the people exercising them stay disciplined and informed. Court victories mean nothing if citizens get careless or complacent. These wins are real and significant, but they don't defend themselves automatically. The officials who built those restrictive barriers aren't surrendering quietly, and the only reason momentum shifted at all is because informed citizens refused to look away or stay silent when their rights were being squeezed. The ground is moving, the legal landscape is transforming, and understanding exactly what just happened puts you ahead of the curve as this revolution continues unfolding across the country. That's it for today, folks. See you in the next video.